When courtroom standards are replaced by kill chain thresholds, what guardrails stop a legal theory from becoming a global manhunt at sea? The memo at the center of this campaign lets the executive branch treat suspected traffickers tied to terrorist designations as lawful targets. The thresholds sit inside classified annexes. Operators meet confidence levels on affiliation and mission, not probable cause for a warrant. Once the standard is met, commanders can authorize lethal force in international waters under executive authority, with reviews running through agency lawyers rather than a judge. That is where the friction starts. Civil liberties lean on transparency and contestability. Counter-terror logic leans on speed and prevention. Without judicial review, mistakes do not surface in a courtroom. They surface when a hull is gone and a crew is missing. Mixed cargo runs raise another risk. A boat may carry narcotics and day laborers hired for pay, not ideology. If the targeting file tags the platform as enemy run, non-combatant crew can sit inside a lethal envelope without ever knowing the case built around them. Oversight exists, but it thins out at sea. Congress can receive notifications, but the details arrive behind classified doors. Intelligence audits can scrub whether sources and methods met internal rules, yet they do not restore an opportunity to contest facts before force is used. Internal legal reviews confirm that necessity and proportionality boxes are checked, but those judgments are made by the same branch executing the mission, often on compressed timelines with limited external input. International law adds another layer of strain. High seas freedoms allow navigation without interference, and sovereignty concerns rise when kinetic actions take place off another state's approaches. Partner nations around the Pacific may see unilateral strikes as a reach, even if the U.S. frames them as counterterrorism. Some partners will ask for shared evidence before lending ports or airspace. Others will worry about precedence. If one state can strike suspects at sea, what stops rivals from citing their own memos and doing the same? There is precedent in targeted killings of non-state actors, where debates hinge on imminence, necessity, and proportionality. Applying that model to suspected narcotics crews stretches those tests. Imminence shifts from a bomb about to detonate to a shipment funding a threat down the line. Necessity weighs interdiction options that do not require a missile. Proportionality tries to map the harm of a strike against the flow of cash and influence it aims to cut.